Okay. Thank you so much, colleagues, once again for honoring the invite for this media briefing. My name is Mkhwebane, and I'm part of the Public Protector Communication team. I will be presiding over this briefing, and maybe just to get the formalities over and done with, let me just introduce the panel quickly. My far left, the gentleman seated at my far left is Mr. Busisiwe Mkhwebane, he's the Chief of Staff. And then next to me here is our outgoing Chief Executive Officer, Mr. Busisiwe Mkhwebane, and of course the Public Protector. Now, without further ado, let me hand over to the Public Protector to address the House. Over to you, people.
Thank you, Program Director, Mr. Sekhalwe, members of the media, the Public Protector officials who are with me here. Good afternoon and welcome to the fourth media briefing for the financial year 2019-2020. For those of you that I have not seen this year, I wish you all the best for the next 11 months. By now, you should be aware that we hold these briefings to bring the people of South Africa up to speed with regard to the progress we have made in respect of implementing our constitutional mandate. We have the power as regulated by the national legislation to investigate, report on, and remedy any alleged or suspected improper or prejudicial conduct in all state affairs or public administration at any sphere of government. Any report issued by this office must be open to the public unless special circumstances require us to keep that report confidential. I have concluded 12 investigation reports since the last time we gathered in this venue on the 12th of December 2019. However, I will focus only on 3 of the 12 reports. The rest, which you will find on our website, carry the following titles: the report on an investigation into allegations of maladministration and improper conduct relating to irregular appointment of a manager for special programs, tender irregularities with regards to the companies procured for the mayoral golf day, and the state of the municipality address by the Lesedi local municipality. Report on an investigation into allegation of maladministration by the Greater Letaba local municipality relating to a tender for the rehabilitation of streets in Mujajislu Phase 2. Another report on an investigation into allegation of maladministration, abuse of power, whistleblower victimization, unfair labor practice, and irregular appointment of an employee by the National Development Agency. Report on an investigation into allegations of undue delay by the Department of Rural Development and Land Reform to allocate and transfer the correct portions of claimed farms to the Tswale community. Report on an investigation into allegation of mismanagement of public funds by the Mopani District Municipality during the 2015-16 and 2016-17 financial years. Report on an investigation into allegations of irregular appointment of Ms. E.N. Ngobeni to a position of IT Systems and Network Officer by the Mopani District Municipality. Another report, number 7, relates to an investigation into allegation of improper conduct, maladministration, and improper application of the Protected Disclosure Act and victimization of an employee by NTP Radio Isotopes Limited. Another report on an investigation into allegation of improper conduct and maladministration relating to the misappropriation of public funds by the Northern Cape Department of Sport, Arts and Culture, and the Northern Cape Arts and Culture Council. The 9th report relates to an investigation to allegation of irregular appointment of the Chief Financial Officer of the Commission for the Promotion and Protection of the Rights of Cultural, Religious, and Linguistic Communities, Mr. Smarts, in 2007. I will also comment on matters of public interest relating to me and the office. In particular, I would like to share some thoughts on the parliamentary process to have me removed from office. But before I deal with those, allow me to reveal my findings in respect of the 3 reports that I wish to highlight. Nkwanyama and versus the KwaZulu-Natal Department of Health. I investigated allegations of maladministration and procurement irregularities involving the Department of KwaZulu-Natal Department of Health. The investigation came on the back of 3 complaints. The first was received on the 23rd of June 2015 by the member of Provincial Legislature of Inkatha Freedom Party in the Provincial Legislature. The second one came from the member of Provincial Legislature of the DA in the same legislature, which reached my office on the 5th of August 2015. The third complaint was lodged anonymously with my office, which was August 2016. All these 3 complaints related to an alleged improper decision to award a mobile units tender to companies trading under the names Mzansi Life Care and Mobile Satellite Technologies by the department. There was also an allegation that the awarding and extension of contracts to a company named Meditech South Africa by the department was improper, as well as that there was a conflict of interest between the department and a certain Mr. Bo in relation to Meditech South Africa. Having analyzed the complaint, I identify the following 3 issues for investigation: whether the department improperly procured the mobile units, and if so, whether such conduct was improper and amounted to maladministration. The second matter investigated whether the department improperly procured and extended the services of Meditech South Africa, and if so, whether such conduct was improper and amounted to maladministration, whether the department failed to consider the conflict of interest that existed between it and Dr. Bo, a director of Meditech. I found that indeed the department improperly procured the mobile units, and the processes followed to lease and consequently purchase the new units were improper. They were not in accordance with a system that is fair, equitable, transparent, competitive, and cost-effective as per Section 217 of the Constitution and the Public Finance Management Act. As a consequence, the department incurred in respect of both the leasing and purchasing of these units, which amounted to irregular, fruitless, and wasteful expenditure. This expenditure further amounts to fruitless and wasteful expenditure as envisaged in the Public Finance Management Act to the tune of 32 million. And the head of department as accounting officer, who has a duty in terms of the PFMA to establish and maintain a proper competitive procurement system, failed to take a responsibility and ensure that the proper control systems existed for the assets of the department when the units were purchased. Along with the CFO, the Chief Financial Officer, the head of department failed to ensure that the payments made to Mzansi Life Care for both the lease and the purchase of these units were approved and processed accordingly in line with the responsibilities entrusted to them in terms of the PFMA and National Treasury regulations. I also found that the department procured the services of Meditech South Africa improperly. The extension of the subsequent contracts was substantial increase in the scope of work was also improper. Lastly, I found that the department failed to consider the conflict of interest that existed between itself and Dr. Bo when it appointed Meditech. Because by that time, Dr. Bo was a director of Meditech. Dr. Bo's conduct as an employee of the state is in contravention of Regulation 13C of the Public Service Regulations, which prohibits employees of the public service from conducting business with the state or be a director of a company conducting business with the state. To remedy this maladministration, I direct the MEC of Health to, among other things, ensure that the HOD consider the acts of maladministration and improper conduct referred to in this report and take appropriate disciplinary action against the officials of the department in respect of their conduct. The MEC must further ensure that the HOD, through the provincial treasury, takes steps to recover the expenditure incurred by the department as a result of fruitless and wasteful expenditure for the purchased mobile units. The HOD, on the other hand, must do all the above and through the provincial treasury evaluate the effectiveness of the department's internal control systems on supply chain management and make sure that he takes corrective actions to prevent recurrence of this maladministration. The HOD must also report to the provincial treasury and the auditor general particulars of the financial misconduct and the steps taken in connection with such misconduct. In addition, the Directorate for Priority Crime Investigation to consider this report and establish if any acts of impropriety identified amounts to criminality in terms of the Prevention and Combating of Corrupt Activities Act. Another report is Singh versus the South African Police Service. I investigated allegations of maladministration relating to irregular awarding of a contract to Tracker Network by the South African Police Services. This followed a complaint by Mr. Singh in August 2013. So these reports are still part of the backlog project. He alleged that Tracker has enjoyed a favorable relationship with SABC since its establishment in 1995. SABC used its resources, including police officials, police vehicles, and aircrafts for the benefit of Tracker to track and recover its clients' stolen vehicles. He also alleged that in the relationship between SABC and Tracker allowed the latter to utilize state resources to fund itself, resulting in significantly higher profit margins for the company than if it were to pay such resources itself. These are allegations. He also alleged that SABC has not benefited from the said relationship as no fee, disbursements, or expenses such as fuel, vehicle maintenance costs were borne by Tracker. In addition, he alleged that the practice was anti-competitive in that other tracking companies were prejudiced, that the agreement between SABC and Tracker had previously been renewed without following proper tender procedures and that the agreement was irregular. Upon analysis of the complaint, I decided to investigate the matter, whether the process followed by SABC in concluding the agreement with Tracker for the provision of the vehicle tracking system was improper, and if so, whether such conduct amounts to maladministration and improper conduct. I further investigated whether the agreements entered into between SABC and Tracker results in the company improperly benefiting from the use of state resources, and if so, whether such conduct amounts to maladministration. I found that the process followed by SABC in concluding agreements with Tracker and Tracker Connect for the provision of the vehicle tracking system in vehicles belonging to SABC were improper. The process followed by SABC in conducting the agreements over the past 21 years failed to meet the standards imposed in terms of Section 217 of the Constitution and Section 2 of the Preferential Procurement Policy Framework Act and amounts to improper conduct and maladministration. I also found that the agreements entered into between SABC and Tracker result in Tracker improperly benefiting from the use of state resources. The SABC utilizes its personnel, vehicles, infrastructure, and aircraft in responding to activation of stolen hijacked vehicles. In this regard, the National Commissioner of Police and respective supply chain management officials failed to comply to the PFMA. The conduct of SABC in this regard amounts to improper conduct and maladministration. To remedy this improper conduct and maladministration, I directed the National Commissioner to, among other things, take note of the report, take into account the fact that SABC does not incur any costs to the supplier installation and use of the devices. I direct that SABC must fervently engage other service providers in the sector in order to prevent possible monopolistic circumstances by one over the others. Such engagement should be undertaken to inform and guide service providers of their needs, specifically the technical specifications of the goods, works, or services that are required. This would allow service providers to either acquire or develop their technologies to meet the needs of SABC and enable them to also enter into such agreements with SABC. The National Commissioner further to consider establishing in-house capacity, which will play a key role when SABC enters into such agreements with a panel of service providers in order not to compromise national security and safeguard sensitive information relating to SAB's standard operating procedures, modus operandi, development, sophistication of crime, and the changing geographical approach to criminals. This should be reflected in the service level agreement entered into with such service providers. The third report relates to various complainants against Ngaka Mudiri Mulema District Municipality. This is a systemic investigation which is relating to the supply of adequate water by Ngaka Mudiri Mulema District Municipality in the Northwest Province to the communities in various local municipalities within the area of its jurisdiction. Between 2012 and 2013, my office received several complaints from different communities in both rural and urban areas regarding lack of adequate water. So this goes to the core of our mandate because it deals with issues affecting the grassroots. On analysis of the complaints, I identified the following two issues to inform and focus the investigation: whether due to its systemic administrative deficiencies, the municipality improperly failed to or omitted to ensure that local communities around its area of jurisdiction receive adequate water. Two, whether the local communities suffered any prejudice as a result of the conduct of the municipality. I found, among other things, that the municipality failed or omitted to ensure that the water consumers in its area of jurisdiction receive adequate water. Although the municipality has made an attempt to adhere to its constitutional obligations, the investigation revealed that most vulnerable groups within its area of jurisdiction did not enjoy access to clean and adequate water. The investigation further uncovered that most of the challenges within the municipality relate to worn-out infrastructure, vandalized or dilapidated boreholes, lack of infrastructure, high cost of water distribution, and poor management of water infrastructure. Central to my findings is that I could not, based on prima facie evidence at my disposal, find any wrongdoing in respect of budget allocated and the utilization therefore. I am, however, of the view that the municipality failed to prioritize the maintenance of water infrastructure, specifically the areas which I will focus my investigation, such as Ramutshere, Moilwa, Ratlo, Mahikeng, and Ditsobotla. The municipality failed to ensure that water service equipment are regularly maintained and that old infrastructure is refurbished. It failed to prepare a water service development plan during the periods 2012 to 2019. I further found that water consumers suffered prejudice as a result of the conduct of the municipality. I acknowledge that the municipality is mostly rural and had for many years experienced water supply shortages, leaving communities with no option but to rely on water supplied through water tanks. In most of these areas where water tankers are used, the storage tanks are not lifted above the ground. There are inordinate delays in refilling the tanks, water is not purified, and tanks are not regularly cleaned. This leaves communities vulnerable to the use of contaminated water. To remedy the situation, the municipal manager is directed to ensure that the following outstanding projects in the following areas within the municipality's jurisdiction are completed: in Zirast water treatment plant in Ramutshere, Moilwa. These include replacing and reinstating pumps, installing electric cables, building protective wall, and ensuring that clarifiers are functional. The next one, Mukhola village in Ramutshere, Moilwa, cycling Eskom electricity account for the borehole at Manogela section, which is in areas. Hopane village in Ramutshere, Moilwa, established the root cause for the malfunctioning borehole, configuring water recirculation network in the high-lying areas, and augmenting water storage facilities. There's also Braklachte in Ramutshere. Also, they need to fix the 3 boreholes in Mkhajana, Hamatin, and Sichotlo section. And Siklahola in Ratlo also appoint a service provider for the construction and completion of the reservoir, completion of a water pipe housing, and equipping the remaining boreholes. Bakaville and Hamaluka in Zobotla, appointing contractor also to construct steel tanker or reservoir, pump housing, and reticulations. Itsuseng in Zobotla also reinstate the pumps at the 8 boreholes. In Kolini, the Zobotla implement the 1.5 pipeline project meant for augmenting of the water supply to the 3 boreholes, to the 662 kiloliter steel storage tanker, and Lomanyaning in Mahikeng. Also, there are projects to be done there. I further directed the MEC of Cooperative Governance and Traditional Affairs to monitor the process of drafting the integrated development plan and assist, coordinate, or take appropriate steps to ensure the planning, drafting, adoption of, or review of such plans. The Minister of Water and Sanitation must appoint a task team to assist the municipality and monitor the process of drafting such water service plan. The Minister must further monitor the performance of the municipality and intervene where there is gross failure of delivery, non-compliance, and the ability to hand over water service functions to different villages within its area of jurisdiction. I also wish to update the public on my investigation onto the matter of the independent power producers and the Frede Dairy project. The IPP's investigation is still at an early stage. Thus far, several witnesses have been identified, and the investigation team is preparing to subpoena those witnesses to appear at a public hearing, which is planned for early March 2020. The Frede matter, on the other hand, is at an advanced stage. We have concluded public hearings of the beneficiaries, as I've indicated several times, held interviews with several key stakeholders, including the implicated politicians, and we have further subpoenaed and received bank records of the specific individuals which are being analyzed. The investigation team is also considering the audio recordings and affidavits which we've received, and which also was presented by witnesses at the State Capture Commission of Inquiry. We have encountered challenges in tracing the representatives of the beneficiaries who are key in this investigation, as they signed an agreement on behalf of the beneficiaries. We have so far only managed to trace one of them, who has relocated from Frede to Gauteng province. Therefore, further information is being sought from them by means of subpoenas in an attempt to trace the representatives, the assistance of the local media, social print, and otherwise had to be resorted to. We anticipate that the investigation will be finalized soon. The commencement of the process to remove the public protector from office. I now turn to the matter that is of grave concern to me, the staff, and without a doubt, the people of South Africa. This is more so for the grassroots communities, who see in this office their only hope at successfully exerting accountability on state functionaries and vindicating their rights. In August 2019, the Democratic Alliance submitted draft rules on the removal of the heads of Chapter 9 institutions from the office of the Speaker of the National Assembly, Honorable Modise. The DA said at the time the move was for the purpose of assisting Parliament in setting up processes for the removal of these heads of institutions. This was after I have written to the Speaker complaining that in its haste to have me removed from office, Parliament has overlooked that it had no rules in place to give effect to Section 194 of the Constitution. My letter in this regard alerted the Speaker of this omission and forced her to go back to the drawing board to do things the right way. On 3 December 2019, the National Assembly adopted the rules. 3 days later, the DA announced that it had written to the Speaker requesting that removal proceedings against me be instituted. That request led to last Friday's announcement by the Speaker that she had approved a motion received from the DA in which the party requested Parliament to kickstart proceedings for my removal from office. I wish to make the following remarks in relation thereto, since we've been receiving a lot of media inquiries or requests for interviews. I'm advised that the rules are unconstitutional and unlawful, in that they amount to a violation of the constitutionally prescribed duty imposed on organs of state to protect the independence of Chapter 9 institutions. The rules also do not adequately provide the audi alteram partem rule, the principle of listening to both sides of the story at all in their application and implementation. They breach the rights of heads of Chapter 9 institutions as provided for in Section 34 of the Constitution, which is in that they do not make provision for the requisite non-participation or recusal of a number of seriously conflicted parties in any of the envisaged processes, including the making of crucial decisions. By way of background, there are several parties, both in the executive and the legislature, who are currently or have recently been the subjects of my investigation. In addition, members of the Portfolio Committee on Justice and Correctional Services in the 5th Administration, who have publicly pronounced and passed judgment on the very issues which reportedly forms part of the subject of the complaint by the DA. I liken this to a situation where a judge, a magistrate, or an arbitrator condemns someone publicly and is later expected to conduct a fair trial of the very same person. The DA is itself involved in litigation against me. I took the party to court to substantiate its allegations that I am a spy. This was a false claim and an insult aimed at undermining my office in violation of Section 181 of the Constitution. The complaint by the DA has to do with matters that allegedly occurred long before the adoption of the rules. The purported retrospective application of the rules is at odds with constitutional values and principle of natural justice. In terms of Section 181 of 3 of the Constitution, other organs of state, including the National Assembly, must assist and protect the public protector and these Chapter 9 institutions to ensure their independence, impartiality, dignity, and effectiveness. The conduct referred to above is at odds with this constitutional injunction. Also of concern is the Speaker's conduct of making public announcement about the process to remove me without informing me of the decision. As I indicated on Friday, I only learned about it in the media. To date, I have not heard anything from the Speaker. This is a violation of my rights to dignity, privacy, and confidentiality, and has the effect of undermining the effectiveness of this important constitutional institution. The pronouncements made by members of the previous Portfolio Committee on Justice and Correctional Service, who accused me of acting at odds with my constitutional duty, making statements that border on contempt of court, and questioning my fit and proper status and proposing that I should resign, are also a cause for concern. These pronouncements were made in full knowledge that all the court cases remarked upon were still pending before the courts, and therefore in breach of Rule 89 of the National Assembly, which bars members from reflecting upon the merits or any matter on which a judicial decision in a court of law is pending. In addition to this, Rule 88 of the Assembly provides that no member may reflect upon the competence or integrity of a judge of a superior court, the holder of a public office in a state institution supporting constitutional democracy, referred to in Section 194 of the Constitution, or any holder of office other than a member of government whose removal from such office is dependent upon a decision of the House. Rule 129R provides that the Speaker shall only approve a motion once a prima facie case has been made out. Such a case cannot be made without having afforded the affected person an opportunity to be heard. The Speaker's conduct in purporting to approve the DA's motion can be regarded as unlawful on those bases alone. I have, through my lawyers, written to the Speaker this morning, bringing to her attention the many deficiencies of these rules, including those I referred to in this statement, and requested her to furnish me with a response. I further requested an undertaking from the Speaker that this grossly unfair process be temporarily suspended until the issues I raise can be adequately addressed. I wish to stress and point out that I'm not against any scrutiny. All I'm asking for is fairness. his office and that of the Speaker of the National Assembly too, are the guardians of fairness and should be exemplary. SARS and DPCI issues. There's also matters of the South African Revenue Services and Directorate of Priority Crime Investigation. You may have seen weekend newspapers that these two law enforcement institutions are investigating my tax affairs and allegations of perjury against me, respectively. I wish to assure the people of South Africa that I'm a law-abiding citizen who pays the taxes just like everybody else. I have absolutely nothing to hide, and I welcome SARS investigators to scrutinize my records in this regard. I undertake to cooperate fully with them. With regard to DPCI, I have indicated that I will not provide them with a warning statement in terms of Section 5.3 of the Pipe Protector Act, which provides that neither a member of the Office of the Pipe Protector nor the Office of the Pipe Protector shall be held liable in respect of anything, in respect of a report finding, a point of view, recommendation expressed in good faith and submitted to Parliament or made known in terms of this Act or the Constitution. I am, however, concerned about what appears to be abuse of state institutions in this matter. It is well-known fact that I have conducted and continue to conduct various investigations that have not gone well in certain sectors of society. Some of these matters do involve SARS. In addition, I am litigating against this institution involving other parties involved in this matter. Similarly, I refer a lot of these matters to the Hawks. Such matters hardly ever receive attention, and yet this seems to be a prioritization of trivial matters, such as this one in question, which can under no circumstances be regarded or referred to as a priority crime. In conclusion, I wish to reflect on the Constitutional Court judgment where the matter against the EFF versus the Speaker, which was delivered by the Constitutional Court, where it says, similarly, the National Assembly and by extension Parliament is the embodiment of the centuries-old dreams and legitimate aspirations of all our people. It is the voice of all South Africans, especially the poor, the voiceless, and the least remembered. It is the watchdog of state resources, the enforcer of fiscal discipline and cost effectiveness for the common good of all our people. It also bears the responsibility to play an oversight role over the executive and the state organs and ensure that constitutional and statutory obligations are properly executed. For this reason, it fulfills a preeminently unique role of holding the executive to account for the fulfillment of the promises made to the populace through the State of the Nation address, budget speeches, policies, legislation, and the Constitution. So this is a very important office. So Parliament also passes legislation with regard to the needs and concerns of the broader South African society. So the willingness and obligation to do so is reinforced by each member's equally irreversibly public declaration of allegiance to the Republic, obedience, respect, and vindication of the Constitution and the rule of law of the Republic. In sum, Parliament is the mouthpiece, the eyes, and the service delivery, ensuring machinery of the people. No doubt, it is this irreplaceable feature of good governance in South Africa, which also the Public Protector is striving to achieve. Thank you for your time.
Thank you, Public Protector. We will now take questions from the floor. I've noted EWN here, and next to EWN, there's some gentlemen here, and then there are two hands that side. So we'll take them in benches of 5 at a time. We have 4 hands now. Anybody else? Okay, let's start here. Thank you.
Thank you, Paul Mkhwebane from EWN Public Protector. So, do you then, when you say you believe this process is unfair and unlawful, suggest that Parliament is participating in a vendetta against you? Because this is quite detailed. You say the rules don't give you your side of the story. Wouldn't that process then include you when it's instituted, giving your side of the story? Because it's the first time a Chapter 9 institution in this country might be removed. So why don't you take that platform to answer those questions? Because if they institute this, then it means you can give your side of the story. Just give me clarity there. Number two, when you say you've taken legal advice regarding this, are you contemplating if the Speaker rejects your request to suspend these rules because you believe they are illegal and they don't follow due process of the Constitution, legal action regarding against Parliament? Thank you.
Good afternoon, Sifiso Mahlangu, Independent Media. Public Protector, I have two questions and they relate to the Speaker of Parliament. I have it from a good source that the Speaker was previously advised by a gentleman called Bejani Chauke, who was the advisor to Ms. Tandi Modise. It also happens that on record, Mr. Chauke was the manager for the CR17 campaign. He having been the advisor, do you think it might impede on her decisions, and do you then hold that she will be fair and just and unbiased to make a decision against you? My second question is, if this proceeds, are you willing to take the decision to court? There are many court cases pending, but maybe to detail it to the IPPs, if you can make a comment. Often in this country there's a discussion that the SOEs were for sale and they were being sold to independent power producers. In your investigation, do you find that comment to be fair? Was there a sale of ESCOM to independent power producers? Thank you.
Good day, Sipo Stillman from SABC TV News. From Protector, you mentioned numerous times that you've had reports that have not gone well in certain power circles. So I'm just going to be direct about this. Do you think this is a retaliation for your CR17 report and the adverse findings that you've made against the likes of Minister Pravin Gordhan in the SARS matter and also in the South Road Unit matter and also the matter of Ivan Pillay? So do you think they fight back because you've rattled the cage in terms of people in certain power positions? Is that what you're arguing here? Thank you.
Good day, ma'am. Lila Magnus, SABC Radio News. I was wondering if you can just explain to us in layman's terms what exactly you are saying is wrong with the rules, why you're saying it's unconstitutional and unlawful.
Thank you. Over to you, PP.
Bonga and EWN, as I've detailed in this statement, that the issues or the process which has been followed in drafting the rules, and also the issue of the constitutionality of the process, because remember we're a constitutional state and we operate in a process where everything needs to be done in such a way that the constitutional values and principles of natural justice are embedded in whatever we do. And I think that's why I even read what the National Assembly and the Speaker is expected to be doing, because it's a constitutional institution which also needs to make sure that this is followed. So I must indicate that the letter which has been written to the Speaker, it's a letter which needs to clarify certain issues and bring these challenges to her attention again, even though the process took place without even being informed as an individual who is said to be the subject of this process. So we will engage with the Speaker, and we've written the letter, we've given her an opportunity to respond. So if the Speaker doesn't respond, as I've indicated, we are engaging with the legal team, who will then view or take other relevant actions to follow. I must indicate that I stated in that letter that if we can amicably resolve the matter, so I don't think it will reach that particular level of engagement. And on the issue of independent power producers, the question by Sfiso, that Bejane was the advisor of the speaker in the past, whether it can impede her decision or being biased. I wouldn't comment on whether that is the situation, because I don't want a situation where it will be as if I say the speaker can't reason as an individual or independently in that. But yes, if that's the case, that Bejane Chauke, who was also the subject of our investigation in the CR17 investigation, so in a way, if he is the advisor, possibly he's also the one who advised that the speaker or the deputy speaker must join as the applicant in the Busasa investigation, which is also one issue where you then check the constitutional responsibilities of the speaker in the National Assembly, which is supposed to be an oversight over the executive. But in this particular matter, there's that interesting issue of them joining as applicants. And the speaker is supposed to be the institution which is overseeing the executive. So if this proceed, will I take the matter to court? As I indicated, that I hope that won't reach that stage, because at the end of the day, if this matter can be resolved amicably, but then we are working with the legal team on this matter. The issue of the IPPs, I've indicated that the investigation is at an early stage. We've received all the documents which we require, and we are identifying the witnesses, and we would want to conduct a public hearing where we will then go deeper into how were they approved, who approved, what does that entail, especially to follow what the complaint which we've received. Again, it's a complaint which we've received. We will determine in that analysis of the information what areas to focus on. So I wouldn't just conclude that indeed that's the case. Sipo from SABC, that reports have not gone. It's not a secret that, and that was also mentioned by Chief Justice Mkhwebane in the Gandla judgment, that unfortunately the public protector will touch the untouchables, and touching a raw nerve. No one will be happy when you investigate them and have a finding against them, and that person will make sure that they possibly retaliate in whatever manner possible in the circumstances. So I must indicate that I once said, since investigating the SARS rogue unit matter, there were several instances where I received threats, poisoning threats, the way my mother was treated, and all those issues which I've mentioned. So I wouldn't be surprised that possibly that would be a process of utilizing state-owned or state institutions to settle possibly scores. And at the end of the day, we are here as an institution, and these investigations are conducted by the investigators who are very competent, very experienced. And again, as an institution, we don't just go with the narrative. We don't just believe what the media is reporting. We go deeper, we investigate, we rely on evidence which is before us. And if we've got evidence before us, then we make a finding. So I think that is a fact. You said your name is malpractice, I think. In layman's term, what's unconstitutional about the matter? As I've said to you, one instance where you go publicly yourself and paint this person incompetent, must resign, they can't do their work, and you are supposed to again sit and be the decision maker about the fate of this person. We operate within the principles of constitutional values, principles of national justice. So this process must be very, very fair in its nature, and the rules must be detailed. Again, there's a lot of gaps which are there in the rules, and the law doesn't apply retrospectively. You cannot even legislate to deal with something which happened in the past. Same applies when you have inefficiencies in your administration or in your company, and you want to legislate for that. So I think this is a process which, as an institution, we are saying, let's not create a constitutional crisis as a country. Let's make sure that we stick to what the Constitution is saying and follow that. It's not only about me. It relates to all Chapter 9 heads of institution. Today is the Public Protector, tomorrow might be the head of the Human Rights Commission or the Auditor General. Interestingly, there's a new law where he's also expected to penalize and to even open criminal cases or civil claims against the repetitive audits. And that won't go very well, Sipho, because the same thing, people won't be happy where you, as a CEO, or a DG, you are told you must pay back 32 million because it was a fruitless, wasteful expenditure which repetitively you've been doing, so you were careless or reckless. Therefore, those people will try by all means to fight you whatever possible. So, in layman's term, I'm saying let the rules be constitutional and let the rules not be focusing on certain individuals, on Busisiwe Mkhwebane. Let whatever they are coming up with be something which will be used by the country going forward and development of the law. So I think that's that.
Thank you, Public Protector. Are there any more questions? I see Olga wants to have a second bite. And there's Liso as well. I see Ravuo there as well. There's Sipho and the gentleman from the Protector team.
Thank you, Opa. Public Protector, you're saying in this line, I, in addition, am litigating against the institution which is SARS in a matter involving the former president. Do you believe then that SARS is being used, in this instance with your taxes, as a political ploy against you because you've taken these actions? Because you've mentioned the former president, you've mentioned the CR campaign. So do you question the authenticity of their actions because you think they target you of your reports relating to the government now? And number two, the issue of the Chapter 9 institution and you being at the center of it right now, with these legal battles happening, you've lost some cases in court, you've won some, do you think then it poses a negative perspective on the Chapter 9 institution, because you are the face of this institution at the end of the day? You might be Busisiwe Mkhwebane, but you are the Public Protector. Does your fight with Parliament, with the government, with everyone who's taking you to court, put it in jeopardy then?
Busisiwe Mkhwebane again. I just want some feedback on a report concerning the rogue unit, and that report relating to Minister of Public Enterprises, Mr. Pravin Gordhan. And in your previous finding, you relate that you have found the existence of a rogue unit, but you go into detail about that. Since that matter is in court and the rogue unit still being in existence because it wouldn't have been, the matter would not have been resolved in court, what dangers still persist? You find that there's a rogue unit running a parallel state security agency in South Africa. That matter goes to court. In my view, that rogue unit would still be in play. That rogue unit would still be in existence, as legal as your findings say that it is. What mechanisms do you think to put into place to impede? If an illegal unit is in SARS, how legal is it that it continues while your matter is in court? Do you think to approach state security thereof or become a friend of the court in that relation? I'd just like some feedback on that. Thank you.
Thanks. Vulnerable or ENC. Public Protector, you just said that in the course of this office doing its work, you will touch a runner from time to time and you will touch untouchables. That said, the fact of the matter is that the National Assembly has approved this motion to have you removed. And from the sense one is getting is that it is a game changer in the sense that the ANC may just support whatever outcome. And that may be the game changer. Are you not worried? My second question is, there are several reasons that people have put out there for wanting to have you removed. Have you at any point sort of taken a step or two back, paused, and look at the work you have done, and perhaps just to make sure that your detractors may not be right on at least some of the cases or issues that they're raising?
Thank you, Sikostilman from SABC TV News once again. My question is actually related to the last one. I was going to ask that I've covered, and I'm sure many of our colleagues, a number of cases here in court battles where it did not go your way, where judges have had adverse findings against yourself and had very harsh words regarding your competence to carry out your duties. So at what point do you take the responsibility as a protector for the process that's underway now? At what point do you look at your own work and question if you've done the best and that perhaps the manner that you might have conducted some of these reports that have been lambasted by courts might have put you in this position where now is this possible? Well, there is this process now to remove yourself. So at what point do you take responsibility as a public protector for the situation that you find yourself in right now? Thank you.
Hi, Public Protector. This is Christian Busisiwe. I'm from Network 24. Public Protector, with this process going on, have you considered resigning? And why, if not, why do you think it's important just to remain in your post? It must have, the last year's drama must have taken a personal toll on you as well. So why did you decide to stay in your post?
Thank you. Over to you.
Yeah, Bonga, the litigation against SARS, yes, SARS has also opposed, in fact, it's the litigation process which we are busy with, and I said it that, there will be that perception that one is litigating against these institutions, and there might be political issues which are involved in this matter. Because if we are fair and objective in the whole process, I indicated several times that I didn't go around and fish for this investigation or any fishing expedition. And the investigators who were investigating these matters have evidence, and we have evidentiary proof, especially on such matters of Pillay. There's memorandum submissions where the former Minister of Finance approved. On the road unit matter, we have evidence and submissions where the former Commissioner of SARS approved, Mr. Kotan. So unfortunately, sometimes people will use such reports. I think I've mentioned that indeed some people will fight. Isn't it in the past some people were saying it's a fight back, or people are fighting. So it means if such statements can be made, it means some people are also using such reports or such issues to use anyone who's willing to be used. So I'm saying it's a perception which is there, that it's as if now there's that fight. And it's questionable what the law is saying. What years can you audit a person compared to the 7 years which I'm expected to be audited? being a public servant, submitting my tax returns every year. So I think, as I said, I'll cooperate with the investigation and we will hear how the matter goes. And whatever evidence they have, I think they will also follow the principles of natural justice, give me an opportunity, show me the evidence which they suspect, and also I will have to also from my side show them why such evidence which they have, and explain myself. So the losing of cases and won some, you know, we've been saying repeatedly again and again and again that you cannot use the judges and the judiciary to deal with the competence of the public protector. And we've been saying also that as an institution, an ombudsman institution, now going back to an ombudsman, unfortunately South Africa is one of the few countries in the world which has binding recommendations. Other ombudsmen, they don't have. Now we are put in a situation where anyone you issue a report against will want to defend and protect their rights, which is a normal process. And these matters, when they are taken to court on review, yes, judges can comment, but at the end of the day, I think let's focus on the core or on the gist of the matter, whether our investigation and whether our investigation also, what benefit are our investigation towards the public. And as a judge, when you issue any judgment, I think you'll always have to have that complainant or that person at the grassroots. Whatever judgment you are issuing, what are you doing to making sure that that person who is prejudiced is receiving justice and is protected from the state. So the fact that there are some judgments which were not in favor of the public protector, it's not a reflection on the competency of the public protector. Because, I mean, if we are not happy with that judgment, judges, how many judgments of theirs are taken on appeal? And the Supreme Court of Appeal says those aside, they also made comments or negative comments about them, or even to the Constitutional Court. But were those judges ever being questioned or being removed because, or being, well, people saying they are incompetent? I mean, some judges, you know, sentencing people to life, whereas they have not committed that act, and the higher court set aside that judgment. Or sometimes a serial rapist or a murderer, because of the incompetence or wrong application of the law by the judge in the lower court, leads to the setting aside of that judgment, and that person will be out there roaming the street. So I think for me, if we're going to use the court judgments, it's one thing, because the decisional independence of the public protector also goes the same way. If you are not happy, take us on review. If we are not happy, we take you on appeal. We saw the rogue unit matter. Yes, our finding was that the rogue unit existed. There are submissions and memos which were signed by the former commissioner to the Minister of Finance, then Mr. Emmanuel, and where they were requesting that they fund SSA to have this unit, whereas we have evidence that by then that unit was operating. We have details of those people, we have all the information, and we have records of the systems and the equipments which were utilized, where we had to have the findings that that is only the competency of the SSA, and unless the president approves that, an institution like SARS can have that institution of their own. And I think we've said several times that SARS has that responsibility, and we are not questioning them to conduct investigation, especially where there's money laundering, where there's issues relating to poaching, customs violation. So they can do that, but they need to do that within their relevant legislation. When it goes to a situation where it involves the mandate of the State Security Agency, then the law doesn't allow, and there are certain requirements to be adhered to. So It's for the state security age. I won't comment on their behalf because, I mean, it will be worrisome for them if that institution is still operating, if the matter is still in court, and if those equipments are not yet recovered. But what I can say is that there was a court case which the Minister of State Security took, in fact, was worried about the availability of that report of the IG, where at the end of the day she finally complied to our remedial action, gave us the redacted copy of that report and of the Inspector General, and we also requested that they need to follow up with the SARS, receive all those equipments because they need to be kept by the State Security Agency. So the matter is still ongoing. I think there will be a hearing soon on the matter. So we will hear what issues are there, and if there is also something we need to assist the court on, because remember the Constitution is very clear about who has the mandate to have that responsibility. Vuyo, the Public Protector and South Africa, we are called Public Protector because in the Constitution is provided as Public Protector, and the staff and the Public Protector delegate her investigative responsibility to the investigators who are continuously doing an excellent work. And you are saying the Parliament has approved the removal and the ANC might support that. You know, I've been saying several times that and some people would want me to be removed, whether I pause and look what work has been done. We've done sterling work for the past 3 years being in this office, and I think there was a stage where we've also published what we have done. And it's not Busisiwe Mkhwebane alone. Now, wouldn't it will be humanly impossible for me to have finalized around 44,000 complaints. But as a team, we've done that. I wouldn't have investigated and analyzed information which led us to issue more than 150 reports. And whatever we are doing with the staff is to change the status quo. And always I say to them, it's not about only investigating or closing the matter. Ask yourself, what have I changed in the life of that person I'm assisting? Or what systems or inconsistencies or maladministration has been happening, and as an institution we've got the power to change that. So we have done that in the last 3 years as an institution, and me being the leader of the team. So we have done that. Therefore, whatever the decision of the parliamentary process can happen, it's fine. It can take its course. But my issue is, let's do things the proper way. Let's not just do things to deal with Busisiwe Mkhwebane. Let's, whatever rules we're coming up with, whatever process we're following up, let's make sure that we are not in violation of the law and the Constitution. And again, the interesting part is every person we've issued the report against, whether they violated the law, and how do we deal with corruption, how do we deal with maladministration, when you have then the executive, the state-owned institutions, whoever has the resources, once you issue a report against them, then they must go to Parliament and say, this public protector must be removed, because it's not about me, it's about other public protectors. What are we saying to us being a constitutional state, to us being an exemplary in Africa, especially how the rule of law, and we need to eradicate corruption, we need to make sure that there's good governance. But at the end of the day, if that process happens, it will be happening. But I've done my part leading this team. SIPO, the court battles, adverse findings, harsh words. Well, I've said it to Bonga. I mean, people have a right to take us on review, and whether the judges have mentioned harsh words, we learn from those, and we do analyze those court judgments. If we don't agree with them, remember, we take them up to the Supreme Court of Appeal, because different judges might come up to different conclusions, especially whatever we oppose, we make sure that we don't allow a situation where the judge will come to a conclusion based on what one party is saying, but we assist the courts to come up to the proper conclusion. And as I said to you, any matter which is before court is for those judges as well, to just sit back and ponder. Dealing with Busisiwe Mkhwebane versus assisting those people at the grassroots who don't have water, who don't have basic necessities of life. So I think it's for them, and I think justice is about that. Do we have to make sure that there is justice for everyone, irrespective of their standing? So we do analyze those reports. We have a legal services, our reports go through the legal service, legal team. They go through them, they check the application of the law, because basically what we do, we check what happened, simple, in layman's term. Malchus, you said I must say it in layman's term. We check what are the facts, what is the law saying or legal prescripts, and whether there's any gap between the two. If there's a gap, we say you violated this, you have not complied with these provisions of the law, period. Everyone who's taking us to court, sometimes they'll take us on procedural issues, not focus on the core of our matter. So we learn, we do take accountability, and I do take accountability, because if you can see in our leadership meetings or in our dashboard meetings where we discuss some of these reports, how they were prepared, their quality assured, legal takes or comment on them. So we're not just neglecting those comments. So we're learning from the process, and we do take accountability. So network, have I considered resigning? No, sir, I have not, and I won't resign. As I said several times, that I'm here to serve, and I'm here to make sure that I change South Africans or people's lives. Yes, if the process of Parliament leads to my removal, it will be God's way of doing that. His will be done. As I indicated several times, I'm in this position to serve, to change the lives of the people, and He used the people in Parliament to put me here, and if He'll use them to remove me, so be it. But at the end of the day, every day we are working, we're changing people's lives. So why stay in my post? I will stay as much as I can, and to change and to deliver our services to the people, to the poor, to the marginalized. That's my only focus. My only focus is the people of this country. I'm not focused on fighting people or public officials, but I'm saying let's do the proper thing of, or we are here to assist you to deal with, inequality, poverty, and unemployment, because we give them solutions on how you can change the status quo. I was mentioning one meeting here, social development, where they were having the students who are recipients of social grants who've performed well, where I was saying to Minister MEC Lusufi that it's so interesting. We issue so many reports, and now the issue of Mbiyazi, if the schools and everyone would take our report serious, would have read the Madiba report, they've read there's one report in Northwest we've issued, where there are instances where we had a finding against the university because of the drowning. But there we are only focusing on what systems you need to have. It's policies, comply to your policies. These are the things you need to do to prevent the recurrence. Then we wouldn't have situations where we have children drowning at schools, where schools are supposed to have processes in place. So that's all we are doing as an institution. Thank you.
Thank you, Public Protector, and thank you to the colleagues for the interest in our work. I now declare the conference adjourned.
The conference adjourned.